It is Tuesday night at 8. Welcome to Pandora's Box Chat Show. Tonight we're looking at arrear maintenance. With me as always, Felicity Guest.
Good evening, Leila. Hello viewers, welcome back.
So maintenance and arrears, probably the biggest issue that we as women have when it comes to the payment of maintenance.
Yes, I think arrears is definitely the most frustrating out of the two. Very problematic because there's a confusion, I think, in the interpretation of the law or the desire to enforce the remedial action in the law because it is a criminal offence, and there's this reluctance on the part of the Department of Justice to actually criminalise arrear maintenance.
But do we actually understand, as Pandora's and Zeus's, do we actually understand that it's a criminal offence when it comes to the payment of maintenance?
I think that there's a clear understanding that it is a criminal offence, but the problem is, and we've mentioned this previously, is that there are no consequences. So just like every other law in our books, if there's no consequences, people will keep disobeying the law, and this is a big area.
So it carries a jail term, but in practice, what does it actually mean?
In practice, it means they'll be given an opportunity to try and pay the arrears, because the ultimate aim is to get the financial support for the child. It's not to put the respondent or the defaulter into jail. So that's the reluctance, because they're going, if we put him in jail, then how can they be economically active? But there is a provision, and it's been applied before through the High Court in Durban, where they instituted periodic imprisonment. So they check in jail on a Friday night, and they check out again, I don't know if it's Sunday night or Monday morning. So it doesn't interfere with the economic activity. But you only have to do that once. Who wants to go and spend their weekends in jail? The problem with that is that the Department of Correctional Services cannot cope with weekend offenders. Let's just be very clear again. The Criminal Act is having the ability to pay maintenance and intentionally not paying the maintenance. That is the Criminal Act. The Act, you will never be convicted of a criminal offence if you do not have the means to pay.
Okay, it's two different things.
Okay, so where the arrears, if they never had the means to pay prior to being in court, and they are found not criminally guilty because they've been unemployed, then the magistrate could rule, and I have heard that before, because he hasn't had the means up to that point. But if somebody has intentionally withheld maintenance and they've got off on a technicality, how can you write the arrears maintenance off?
So how successful are Pandora's in gaining access to their arrears maintenance, the maintenance in arrears?
I'm going to say this categorically up front. It depends on the will of the Department of Justice employee, and whether they want to actually enforce the Maintenance Act or not. Because where you have an official who understands the impact of it and sees the criminality, they rule that they get a suspended sentence invariably. Should they default again, then it will be imposed. Otherwise, they encourage you to rather go the civil route. They generally will not go the criminal route unless they have tried the civil route and there's been constant defaulting on the agreement reached from the civil process, which is you in arrears, you've been to court, and there's been a process to give the default an opportunity to actually make good on the arrears.
Every court has different officials, but there's one law. So is it by interpretation, or like you said, by understanding it differently? Shouldn't there be one rule and everybody follows that?
Yes, there should be. In law, we have the magistrates and we have judges. Now, the magistrates do not have that much leeway with the law because the acts are very clear and they're there to apply the acts and to apply their mind as to whether or not they've transgressed those acts. That's the magistrate's function. As opposed to a judge has a lot more scope to take into account extenuating circumstances, previous precedents, But the high courts do not deal with maintenance issues. They send them back to the magistrates' court. So to answer your question, it should be. It should all be interpreted exactly the same way, and we should have consistency throughout the country. When I arranged the protest in 2017, that was one of my questions in my memorandum to the Minister of Justice. The Deputy Minister of Justice's response to that specific question was, we cannot interfere in the independence of the judiciary, and it's open to interpretation by the presiding officer. Yes, for a judge, absolutely, but not for a magistrate's court. The Maintenance Act is very clear on procedure and remedial action.
Because there's been a vast difference between my outcome and another person's outcome. And it was, should actually have been the same. Because situations were similar, but I got, again, the shorter end of the stick, or rather got beaten by the stick.
Yes, you did. And that's the biggest problem is if you don't know what your rights are and you don't know what the procedures, that's what's critically important, that people know procedure and understand the recourse. And that is where we've been pretty successful on child maintenance difficulties, is empowering parents to know procedure and to know what the child's right is and what the Maintenance Act says. It's very simple. And very often when the official, whether it's the clerk or the prosecutor, is challenged, they invariably change the direction of the tactic of that particular thing. Because if you don't know that it's supposed to be this way and they rule a different way, you'll just comply and accept it. But if you know that that's not correct and you go, sorry, I don't accept that because the Maintenance Act says, let me just take out the Maintenance Act that I have here, and here in this particular section, this is what it says. They have to follow procedure.
So on that note, give us a bit of a background on our Pandora story for today.
Sure. So Pandora's story is a common one. 2 years in the maintenance system to try and claim arrears of in excess of 250,000 Rand. And again, he didn't arrive in court and he was subpoenaed. So this is a bit different. They issue a summons because you are to appear in criminal court. So they'd obviously exhausted the civil route. He didn't appear in criminal court, so a warrant of arrest was issued. He was given a suspended sentence for not arriving in court, not for not paying maintenance. Let's just make that clearer again. And 2 years down the line, then when he did appear in court, he said he's unemployed. But the investigation had proven that his lifestyle did not match that of his status that he's declaring. He was employed, but he was receiving his money in cash. So there was no
track record of that.
Pay slip, but they did a lifestyle audit. And there again, the investigating officer, the maintenance investigating officer, is mandated to do a thorough investigation. So he can go to the banks, he can go and visit your house and have a look and see how you live. He can do a deed search, he can do a search on your car to see who owns your car. All of that is available. But with the amount of cases that they have to investigate, they just don't get round to it. And by the time they do, you're looking at 2 years down the line.
I was going to say, how do you access that investigator?
Well, every maintenance court should have an investigator. It's procedure. If you go the criminal route, then the maintenance investigator has got to investigate the matter, because that's what goes to trial. The evidence that he produces is what is presented at the trial. So if somebody knows what the procedure is and suddenly they're in the process themselves and they go, hang on, this is not my understanding of procedure, they'll always come back with another answer. But if you come back up your statement or your question with facts, which is very simple, it's a Maintenance Act, then they've got to comply.
So Felicity, I think on that note, let's invite Dave Dewar to come and help us unravel all these issues and give us perhaps a little bit more insight and answers on all these difficult questions. So do stay with us, we'll be right back. to Pandora's Box Chat Show. We are now joined by Dave Dewar, our legal expert, for this episode to help us unravel Pandora's story and get some more answers to the difficult questions that we are dealing with. Dave Dewar, very warm welcome and thank you so much for being with us again.
Good evening, Leila. Good evening, Felicity. It's nice to be here again.
Hi, Dave. Thanks for joining us again. Is it absolutely necessary to have a legal representative assisting you to get the arrears maintenance? If not, how easy is it for a claimant to handle the process herself?
Well, Felicity, the court system is already set up that you've got a maintenance officer whose job it is to assist in collecting arrear maintenance. So they're the person who runs the the maintenance court, and they're similar to a prosecutorial kind of role where they oversee everything. They manage the court roll, they start the court, they end the court proceedings, and they are there specifically to assist people in getting arrear maintenance and processing maintenance applications. So with them there, they're obviously experts in what they do. You don't need a legal representative. The time when I would suggest that you have a legal representative is if you have a warrant of execution issued, because of course a legal representative knows the sheriffs, has arrangements with the sheriffs in terms of account payments, etc., understands those processes a lot better, and in that case I would suggest that you use an attorney. But if you are going to go directly to the court, you don't have to have an attorney or legal representative with you. Of course, if you have the finances with you, then it's always a good idea to have your own person there, because they're there for you. The maintenance officer is there for everyone, and it's very difficult for them to take one particular case as seriously as your own attorney would. So from that point of view, it's not going to cost you anything if you use the court processes, but bearing in mind that there are limited resources and they have to spread themselves very thin amongst all the applicants every single day, 5 days a week, 21 court days a month, and however many that works out in a year. And it's a big ask for them to remember particular cases and to give particular cases the depth of attention that they would require.
Okay. So, Dave, if you pursue the civil route to claim the arrears and there's a warrant of execution and attachment of property, one of the complaints that we often have on our group is the fact that the claimant is having to carry the costs of the attachment and the storage for a period of time, because the respondent still has a chance to appeal this. Why does the state not carry the burden of costs?
Felicity, that is a short question with a very long answer. There are two aspects that you've raised there. The first one is, of course, the question of the costs, and the second one is the question of the appeal. So first I'm going to deal with the cost, because that's quicker and easier to deal with. And the short, there is no perfect system. At the end of the day, the sheriff is appointed to execute the warrant, amongst the various other documents that they work with. They've got their costs, they've got their overheads, and those need to be paid. So the way it works in all civil situations like this, magistrates court, high court, labour court, whatever it may be, and obviously maintenance court as well, is that whoever instructs the sheriff to execute the warrant carries the costs. Those costs are then later recovered through the warrant, because that's how the warrant is drawn up, is that you recover the costs as part of the assets that are sold. So there is unfortunately no perfect system here, but that, again, it's the choice of going the route of the warrant versus calling someone into maintenance court. So it's a trade-off, because if you go this route, yes, there will be costs attached to it, but it's this versus spending days in court and going in and out of court, having evidence heard, why hasn't he paid, and going the criminal route for contempt of court. But I would still suggest going this route, because it's going to be a lot quicker. You're going to get a quicker result out of it. And if the defaulter has assets, you sell those assets. And the next time that they're in default, they're going to think quite carefully before anything goes, because you've actually got a result that hurts them in the pocket. And it's quite quickly and it's effective. The second part of this, you mentioned that the defaulter has the right to appeal against the warrant. Okay, so you have two processes that I need to talk about. What happens if you go and attach goods and the defaulter is sharing a house with someone else and the goods that are attached belong to the other person? That person is entitled to bring an affidavit to the sheriff, and that would start what's called an interpleader proceeding, which then would suspend the warrant until such time as those proceedings have been heard, where the claimant would stand up in front of court and say, these goods belong to me, here's my proof of when I bought it, this is how long I've had it, or I inherited this from my parents when they passed away. They have to show that they own those goods. If, of course, they're successful, then they get the goods back. If they're not successful, those goods are sold. Then, once the interpleader proceeding, assuming there has been one, has been disposed of, then the goods are sold in execution. But where one has to be careful is if there is an interpleader proceeding, you don't want the sheriff to remove the goods from the house and put them in storage until that interpleader proceeding has run. Because while those goods sit in storage, the claimant is going to be paying the cost of storage. So you have to be quite careful about that. You only want those goods removed as close to time of sale as possible. And that you, through your attorney or through yourself, you arrange that directly with the sheriff, have those conversations. The sheriff is there to provide a service, and they will cooperate and work with you on these things. Then the second part of that is in terms of having the warrant of execution set aside. They can have the warrant of execution set aside in terms of the Maintenance Act if they have complied with the warrant. And there are a number of other smaller provisions that relate to it, which I'm not going to go into in detail here. But there's no actual appeal against the warrant. They can't do that. You can appeal against the court order, you can appeal against the judgment, but you can't appeal against the issue of a warrant of execution. So just to get everyone's terminology correct, it would be an interpleader and then setting aside.
If I feel my case around my arrears maintenance was not handled properly, where can I go to complain or perhaps readdress the issue?
If your matter is not being properly handled by the maintenance officer, then your immediate course of recourse is to take it up with the court manager. Go see them, discuss the matter with them, possibly write them a letter or go see them and give them a letter at the same time, because of course if things are put in writing, they're always more likely to be addressed. But at the same time, face-to-face also works. So do both. Go see them, say, here's a copy of the letter setting up what my complaints are. These are my complaints I'm giving to you in person. Thank you very much. And then hopefully you will get an answer from them and things will move forward. If you're not happy with what the magistrate has done, assuming it's a final order, then you can take it on either review or appeal, depending on the situation. On appeal, if you feel the judgment is wrong, and on review, if you feel that the magistrate was biased in the case, they've got a personal interest, they know the defaulter or something like that. There are certain provisions relating to that. I don't want to go into too much detail, but that you can always try and do that personally, but again, you're going to find it quite difficult because there are particular processes that have to be followed. There, you're probably better off instructing an attorney, and I think you would get a better result out of it that way.
Do you perhaps have any advice to our Pandoras out there who are currently struggling to get their arrear maintenance back?
Leila, the Maintenance Act, and of course being the legal guy, I'm going to tell you what the law says. The Maintenance Act allows for the criminal proceedings where you would bring them into court and you would charge the defaulter with contempt of court. The second one, as I've laboured quite a lot on this today, is the warrant of execution. The third one is what's called an emoluments attachment, where you would go and attach a portion of the defaulter's salary so that they pay monthly based on that. And then the other one is to go and attach a debt. So if someone else owes the defaulter money, you can get an order from the maintenance court saying that, let's say he sold his car, and before that payment is made to him, you go and attach that from the dealer so that it's paid for arrear maintenance. So you can do that on any sort of debt that is owed. you can go and do that with a bank account, because at the end of the day, if you give money to a bank, I know this is going to sound a bit strange, but the bank actually owes you money. It's your money, so you can go and attach his bank account if you want to. So those are the ways that you would find that the Maintenance Act provides for you to go and get arrear maintenance. And the other thing which I must stress is that when you're sitting with the maintenance officer, and the maintenance officer says to you, the defaulter has made an offer of, let's say, 1,000 Rand a month towards the arrears. If you're not happy with that offer, you can say, I'm not happy. Tell them I need more on the arrears because it's put me in a difficult position, or whatever it may be. You can counter offer. You can say, he's offering 1, I want 2, or 3,000, whatever might be appropriate. And if the maintenance officer wants to push you in a position where you're not happy, you don't have to accept it. You can ask them to put the matter in front of the magistrate, and you can make your case to the magistrate and ask the magistrate to give you a higher order than what the maintenance officer and what the defaulter has offered.
Dave, thank you so much for joining us this evening. Thank you for all that wonderful information. I really think I need to come and sit and talk to you about my problems that I'm experiencing.
Well, Leila, again, I'd like to thank you for allowing me to come on the show and being able to speak to Pandora and helping her, guide her through the difficulties that she's having. I need to just let you know, I get a lot of people that will tell me, they hear I'm an attorney and they go, my ex owes me maintenance. And I'll say to them, well, what have you done about it? No, well, I've decided I don't want to do anything because, for the peace of the children or whatever it may be. But then all they'll do is they'll complain about it. The Maintenance Act is quite strong. And once someone is in the system may be slow. It may not be the most efficient thing that you'll ever come across, but it does work. It does take a long time, but it does work. And the only way that you're going to get the arrear maintenance due to you is actually to fight for it. You have to go to court, get into the system, use the system. The system is there to help. So use the system, get the maintenance that's due, because at the end of the day, it will make a better life for yourself and for your children. So thank you very much for allowing me to come onto the show, and wish you and everyone else a good evening.
Thank you, Dave.
So Felicity, as always, there's so much more around these issues that we are dealing with, and we can't possibly get to the answers in a short space of time. And I really think this is something that I want to really dig deep into, because I honestly feel that we need to get to a space where our court systems are working for us and with us to resolve these issues. And it's not about Pandora or Zeus being right or wrong. It really is about the best interest of the child. Is the child getting what he needs or she needs at that particular space and time, and that we don't end up waiting 2 to 3 years before we get access to some money in order to help the child with their basic needs.
It should be a lot simpler. The child needs to be provided for. And if the state is so considerate, then maybe it should go the route of some of the other countries in Eastern Europe, where they pick up the tab for the arrears maintenance. Absolutely. And they claim it back from the defaulter. If they're that sympathetic to the defaulter, let's focus on the child. So
I would love to see that happen. Maybe in our time still. And on that note, we're going to leave it there for tonight. Thank you so much for tuning in. Do remember to subscribe, like, comment, and remember to stay tuned for our competition. Right after this, we'll be announcing the winner. So if you have been a winner on our show, we'd love to hear from you as well. Let us know how you've enjoyed your prize and how that has benefited you. Remember, we will have lots of exciting prizes coming up in the episodes to follow. So always remember, Tuesday night at 8, tune in to Pandora's Box Chat Show. And you're also welcome to email us on talkingtopandora@gmail.com. All the information also on our Facebook page. So head over to Pandora's Box Chat Show on Facebook, and remember to share, because the more subscribers, the more shares, the more views, the more likes we have, the more we can do with this channel, and the more we can have your voice heard. Felicity, until next time, good night.
Good night.